Good day and welcome to you. This is another Paddocks Club video tutorial, and today we pick up on the second half of our analysis of the amendments to the regulations under the Sectional Titles Act, those amendments which were published in October 2011. The Gazette number is on your screen, 34639. If you're interested in the detail, please download it. You'll find it on the internet quite easily. Last week, we looked at the amendments to the text of the prescribed management rules in Annexure 8 to the regulations. Today, we'll have a lightning look at the amendments to the text of the existing regulations and the insertion of new regulations, as well as the amendments to the text of various forms in Annexure 1 to the regulations and the insertion of new forms. A lot of it is fixing and tweaking, but there are one or two, perhaps even three important things. Firstly, there's an insertion of a reference to Section 25.9 in Regulation 5.1M that deals with draft sectional plans. There's a substitution of Regulation 6B, which I think should be 6.4B, and which deals with the submission of draft sectional plans. In this case, the architect or land surveyor has to submit an affidavit confirming that the boundaries between the sections and common property have been physically defined as contemplated in the Act. And then there's the addition of Regulation 10.4, which deals with the application to open a register and deals with how two new forms are dealt with in the application and consent for the substitution of land under a mortgage bond. The first important element where we pause for a second is that the regulations now make specific provision for lost or destroyed Section 11.3b certificates. You'll recall that these are the certificates setting out all the conditions of title, any provisions imposed by local authorities on opening of the register, any conditions or servitudes imposed by the developer. So this is a very important document, and many of these things have been lost or destroyed. So Regulation 13A caters for a process whereby either the body corporate or the developer, if the body corporate hasn't been formed, can make application for filing of a replacement certificate. There must be publication by the Deeds Office and at its expense in the Government Gazette. There's an opportunity to object, and finally there's a filing of the new schedule. Going back to the fixing and tweaking, there's an addition of Regulation 15.8, which caters for amendments to sectional plans on cancellation of a scheme. You'll see two in italics. That's an amendment of Regulation 16, an amendment of Regulation 25. These deal again with replacement certificates, not only of the 11.3b certificate I mentioned a second ago, but also of the certificates of real right under Section 25.10d. Those are Sections 25 rights to extent, future extension rights. And then on the technical side, again, an amendment of Regulation 28 that adds in a reference to exclusive use rights referred to in Section 25.1. The insertion of Regulation 25A, let's pause again. Under Section 25, when you open a scheme and reserve the right to develop future phases of that scheme, you have to put in a whole series of plans and draft schedules which show how those buildings are going to affect the existing common property and how the rights will change, the voting rights, all that sort of thing. That's in the PQ schedule. These two have been lost or destroyed. And so there's a similar process whereby a body corporate or developer, if there is no body corporate, can make application for the filing of a replacement certificate. The Deeds Office must publish that application, and at its own expense there's an opportunity for objections, and finally a new certificate is put in place. Another third and an important one dealing with management issues is the amendment of Regulation 30. Regulation 32 deals with a threshold at which the body corporate can start to make changes to the management rules, and it reduces that threshold from 50% to 30% of units owned by persons other than the developer, i.e. the developer can make changes via the body corporate once 30% of the units are in other hands. And you might ask why I say the developer can make changes. Because it's the body corporate that can make the changes, yes, but the developer normally holds powers of attorney under his deeds of sale. So whilst the body corporate is in fact making the changes, it's normally the developer exercising proxy rights under powers of attorney or powers of attorney under sales agreements that is involved. Going on to the fixing and tweaking, some more. There's a substitution of Regulation 34. The first one didn't make a lot of sense to me. There was some gender fixing, and then the phrase suitable adapted was replaced, was put in place of suitably adapted. I thought the original one was better, English anyway. There is a provision for a new form for a collateral, a sectional mortgage bond, and a surety mortgage bond. There are amendments to various forms, Form F, Form I, Form J, Form O, and you'll see on the screen whether they are just footnote adjustments or replacements of the whole form and for what purpose. And then there are a number of new forms. Form AK, a sectional surety mortgage bond. Form AL, an application and consent in terms of Section 11. 3D, that's an application and consent for substitution of land shown on a sectional plan for the land mortgaged under the bond. Form AM, a consent to the cancellation, release, cession, substitution, etc. of land under a bond. Form AN, here we get to the lost or destroyed schedule of servitudes and conditions in terms of Section 25.2, and Form AO, a certificate of replacement issued in terms of Section 16D of the Sectional Titles Act. These changes become effective on the 28th of October 2011, I remind you, and I thank you for spending this time with me. If we have any further questions, let's discuss them in the discussion forum. Thank you.